हेलो दोस्तों, वेलकम टू आवर चैनल लॉ स्टडी विद एनएक्स। और आज हम देखने वाले हैं सुप्रीम कोर्ट का इम्पोर्टेंट जजमेंट जिसका नाम है नेशनल इंश्योरेंस कंपनी लिमिटेड वर्सेस प्रणय शेट्टी। ये मोटर एक्सीडेंट केस के रिलेटेड जजमेंट है और बहुत ही इम्पोर्टेंट जजमेंट है। तो चलो शुरू करते हैं आज का वीडियो। पर वीडियो शुरू करने से पहले अगर आप हमारे चैनल पर नए हैं तो प्लीज हमारे चैनल को सब्सक्राइब करें, साथ ही इस वीडियो को लाइक करें और आपको इस रिलेटेड और कोई वीडियो चाहिए तो हमें कमेंट्स कीजिए। तो चलिए बढ़ते हैं अपने वीडियो की तरफ। लेट्स स्टार्ट विथ इंट्रोडक्शन। A five-judge bench of Supreme Court in National Insurance Company Limited versus Pranay Sethi has laid down guidelines on the fixation of future prospect in the case of motor accident for victims who are the permanent employed, receive a fixed salary or self-employed. After the analyze the decisions in Sarla Varma and Delhi Transport Corporation, the court concurrent with the view therein regarding to the standardization of addition to the income toward the future prospect in accordance with the section 168 of the Motor Vehicle Act 1988. It is also observed that the concept of just compensation has to be determined on the foundations of fairness, reasonableness, and equability on the acceptable legal standards, since such determination can never be in mathematical exactitude. Superior position. In Salavrama, the court determined and made a rule that 50% actually salary could be added if the deceased had permanent job and if age of deceased was between 40 to 50 years. No addition was to be made if the deceased were more than 50 years. Further, they ruled that they were the deceased was self-employed or had fixed salary without the provisions for annual increment. Courts would take only the actual income at the time of death. The departure for this rule was permissible only the real and exceptional case involving a special circumstances. Prior to the Sarla Varma decision, the practice was to be award 50% of the last draw salary as a compensation in fatal accident claim. Suddenly, the calculation table laid down in Sarla Varma containing the fixed percentage on the basis of different age group was followed for calculating the future prospect for the permanent job holder. It was this straitjacket demarcation between the permanently employed persons within the taxable range and the other category where the deceased were self-employed or employed on fixed salary, which was analyzed in present case. Position present to the National Insurance versus Pranay Sethi. The court determined for the reasoning in Sarla Varma and held that the calculation of future prospect for the purpose of compensating victim should be extended to the persons who are self-employed or earn fixed salary and not just those having permanent job. The court in this regarding reasoned that to have the perception that he, self-employed persons, is like to remain a stick and his income to the remain stagnant to the contrary to the fundamental concept of human attitude, which always intend to the live with dynamic and move and change with the time. The court also remarked that different tribunal calculating the compensation differently on the same fact leads to the lack of uniformity, inconsistency in awarding compensation. Therefore, in order of regulate the calculation of compensation and keeping a view of principle of certainty, stability and consistency, the court agreed to the principle of standardizations so that specific and certain multiplier is determined for the applying the multiplier on the basis of age for the claim where the deceased had a permanent job. Further, the court, considering various facts such as the passage time, escalation of price, human attitude to the follow the particular pattern of life, and change in the price index, among other. Observe that the principle of standardization should be applied for the persons with the fixed salary or self-employed persons as well. The court has therefore laid down the computation of fixed percentage of additional to the actual salary of self-employed persons or the person earning a fixed salary. It also introduced the such calculation of victims between the age of 50 to 60 years, which was not previously available under the guideline of laid down by Sarla Varma case. In summary, the court has determined the applicable percentage for the determinations of future prospect in the case of diseases with permanent job, and also add a category where the diseases was self-employed or fixed salary to be as follow. Diseases with the permanent job. The below 14-year addition made 50% where the diseases was self-employed or on the fixed salary. Below in 40-year addition 40%. Diseases with the permanent job 40 to 50-year addition made 30% where the diseases was self-employed or fixed salary. 40 to 50-year the addition made 25%. The diseases with the permanent job age 50 to 60 year the addition made 15% where the diseases self-employed or fixed salary age 50 to 60 year the addition made 10%. The court also laid down the reason compensation figure for the conventional head in the following term. A. 50,000 in the case of loss of estate. B. 40,000 in the case of loss of consantium. C. 50,000 for the funeral expenses. This amount ought to be enacted at the rate of 10% with the every 3-year rate. This development and the slab laid down the above would go to the long way in the standardization on the mode of computation of compensation in fatal accident case and shall help to the eliminating ambiguity in future case. It shall also save the judicial time by eliminating a need for the detailed calculation by various court and tribunal. आई होप आपको हमारा ये वीडियो बहुत पसंद आया होगा। साथ ही आपको सरला वर्मा केस का एनालाइज देखना हो तो इससे पहले मैंने सरला वर्मा केस का एनालाइज किया था, उसका वीडियो मैं आपको यहाँ दे रहा हूँ। अब यहाँ से आप वीडियो की क्लिक करके एनालाइज देख सकते हैं। काफ़ी अच्छा वीडियो है, आप ज़रूर देखिए। और साथ ही अभी तक आपने हमारे चैनल को सब्सक्राइब नहीं किया हो तो जल्दी जाके अभी सब्सक्राइब कर दीजिए। साथ ही वीडियो को लाइक और शेयर करना ना भूलिए। थैंक यू।